Good afternoon, everybody. Thank you for joining us for today's webinar regarding workplace violence. This is in part a webinar that is done through Conn Maciel Carey's OSHA webinar series, 2015 webinar series, but really this is one of these interesting issues that is a great crossover issue for our law firm, which is a OSHA and labor and employment specialty firm where workplace violence is in part an OSHA issue, which you'll hear me talk about, and also very much an issue that has implications in the employment law sphere, where my partner Cara Maciel will talk about. So we're delighted that you all could join us, and I know that we have a lot of folks participating who generally deal with us on the OSHA side and those that deal with us on the employment side. And so we're glad to be able to talk with you today, both Cara and I, about our respective practices and how they're implicated by this workplace violence issue. Cara and I will both be presenting today. We'll just tell you real briefly a little bit about ourselves, and then we'll dig right into the topic. One of the faceless voices that you'll be hearing today is Eric Conn. That's me. I'm one of the co-founders of Conn Maciel Carey and chair of the firm's OSHA Workplace Safety Practice Group. My practice for the last 15 years has focused exclusively on occupational safety and health law issues, where I work with my clients, with employers, to help manage inspections, investigations by OSHA and the other alphabet soup of federal and state agencies out there that regulate workplace safety and health, and then handle the full range of litigation activities related to those the outcomes of those investigations and inspections, including contests of OSHA citations, investigations and prosecutions of OSHA criminal charges, and then the full range of OSHA guidance, advice, and counsel.
Hi, everybody. I am Cara Maciel, where I am the chair of the Labor and Employment Practice Group here at Conn Maciel Carey, having founded the firm with Eric a little over a year ago. And I handle my practice exclusively on the employment issues that employers face on a day-to-day basis. I not only defend employers in court and administrative actions with issues arising out of the employment relationship, but also do a lot of counseling on policies and procedures with respect to issues that employers face on a day-to-day basis, reviewing handbooks, implementing policies, conducting training. And so a lot of the things that we'll talk about today with workplace violence will be focused on the kinds of workplace policies and procedures that you should be implementing, as well as training issues for your staff. And then, to the extent that there is an incident, we talk about strategic steps that you can take to prevent them, but also to respond to them, and understanding what legal issues could arise out of liability from a workplace violence incident. So with that, I'll turn it back over to Eric. He's going to talk about the agenda and a little bit about what workplace violence is all about.
All right. So today we're going to review, what is workplace violence from the perspective of OSHA. From my perspective, Cara will talk about what workplace violence is in the context of employment law and just our general understanding of operating workplaces and what this means to all of us. We'll talk about some of the trends and the data about workplace violence, what types of events are happening and where. And then I'll talk about the OSHA implications, OSHA enforcement, some compliance assistance issues that are out there, and then some general strategies for how to deal with the workplace violence issue from the lens of occupational safety and health regulatory framework. Cara will talk about the employment law implications of workplace violence, and then we will both talk about, and hopefully you will also be talking about with us, prevention strategies for how to prevent and respond to workplace violence incidents in general and in some specific industries where this has been a particular hot button issue. So thinking about what is workplace violence, this is my perspective on this really from the OSHA perspective. Whenever I think about this and whenever I'm talking with clients or even friends and family about this issue, the first thing that comes up and the first thing that people think about is the active shooter scenario. And that is, and unfortunately we've seen, far too much of that over the last few years in a variety of different work environments. But that's not all that workplace violence is. I mean, that's the one that is covered the most by the media, and it is, the most sort of shocking to us all when it happens. But from a regulatory standpoint and an employment law standpoint and a common sense management of our workplace standpoint, workplace violence is so much more than that. It is, from the OSHA perspective, OSHA talks about workplace violence as any act or threat of physical violence, harassment, intimidation, or other threatening, disruptive behavior that occurs in the work environment. And it's not necessarily the four walls of your workplace. It is any location where employees perform work-related activities or are located for purposes of work-related activities. And that has included, obviously, the traditional workplace, but also parking lots and grounds and areas around your workplace. And when I say it includes that, when there have been, employment law issues or OSHA enforcement issues, it's not just within the four walls that a regulator or a court or another agency might look at to say that the employer has some role in managing. It also includes that, the grounds around the workplace, and also if you have employees who work remote or travel and there's a place that they are expected to be to perform work activities, and there is a risk of workplace violence or an incident of workplace violence, there are real employment implications to that. The list here, obviously not a complete list, but it's just a way to make you think about the different things that are lumped into this bucket. It's not just the active shooter, not just the homicide situation, but assaults, batteries, bullying, harassment, intimidation, and threats are all things that OSHA, I know for sure, are thinking and talking about when they're thinking and talking about regulating workplace violence. Another really unique aspect, perhaps the most unique aspect about workplace violence as a hazard, and this is me putting on my OSHA hat, thinking about OSHA looking at this as a hazard to regulate or a hazard for employers to address. What makes this really unique as compared to the other OSHA-regulated hazards, like the hazard of amputation from working with moving parts of a machine, is that very often the risk, the hazard itself, is being introduced into the workplace by a third party over whom the employer exercises no control or authority. It's one thing for an employee to circumvent your lockout-tagout procedure and put their hand into a machine. That is something that, certainly in OSHA's perspective, you have control over. You could do lots of training, you could do lots of supervision, you could build engineering controls to prevent your employee from taking some action like that. But very often the workplace violence threats are by a person whom the employer has no control over, maybe even a total stranger to the employer. So you can't do training, you can't observe, you can't supervise, and you can't manage. So this is just a way to think about where this threat of violence comes from. The obvious, when we're thinking about workplace violence, the obvious source of that is employees. You have either a disgruntled employee, a former employee, or coworkers with some sort of dispute between them that elevates or escalates into a violent act or threats of violence, harassment, so forth. That's something that employers have a bit more control over. But then you get into these known third parties and strangers, which is what makes this such a unique hazard to try to manage as an employer. Very often the workplace violence incidents that we hear about, we read about, that we know about are happening from a known third party. Domestic violence dispute that spills over from home into the workplace, where your employee's spouse or former spouse or partner comes to the workplace and engages in a violent act to carry out or continue a dispute that started outside the workplace. Sometimes you know about this dispute, sometimes you don't. And all of that factors into whether this is a foreseeable thing that you can control, but it's something that the government, regulatory agencies, and the courts to some extent are putting a burden on employers to own this because it's happening in their workplaces. Other sort of known third parties, and this is sort of a gray area between known third parties and strangers, is the client, the patron, the customer, the patient, others who are in your workplace because it's part of your business to open your workplace to these individuals, and they may be quasi-known to you as someone that you intend to do business with or in the process of doing business with, but they're present in your workplace and they can be a source of violence. Thinking about the context of healthcare delivery, where you have patients, either if it's a mental health care setting or circumstance where someone maybe even has a history of violence, or because of drugs that are being delivered as part of the treatment, their conduct can be altered in a way that creates a violent circumstance. That's happening in the workplace. That's something now we've seen a lot of indications that OSHA and other regulators put a burden on the employer to try and control and manage that. And we'll talk about that in some more detail. And then there's just the true strangers, where you've got late night retail where someone comes in to rob the store. This is not a customer, not a domestic partner of one of your employees, not one of your employees, but a stranger who is coming in to bring criminal intent into your workplace. We've also seen circumstances where it might be visitors of a patient in a hospital, or warring factions of two gangs who are involved in an incident out in the streets. It ends up in the hospital where the injured parties are being treated. Their friends and fellow gang members come with them to visit, and all of a sudden you have a gang dispute happening right there in your hospital. And then the last thing we've seen a fair amount of over the last few years are sort of the random acts of violence, where it happens to be at your workplace, but the idea is some person, either for terrorist purposes or for mental health reasons and attention seeking, engages in sort of the active shooter scenario at your workplace to get the headlines and things like that. So the violent threat can come from a lot of different sources, not just your employees, and that's what makes this such a unique scenario for employers to try to foresee and to manage.
Yeah, so certainly as workplace violence has been in the news recently and continues, unfortunately, to be an issue that employers have to handle and prepare for, this slide really represents how much workplace violence affects your business, not only from the impact to your employees, but also really on your financial bottom line. Right here we've got 18% of violent crimes are committed in the workplace, and 94% of those involve assaults. 21% of those involve guns. Guns, for sure, are becoming more prominent around the country. It's part of the national discourse right now on the political scene, and more states are passing laws that do allow concealed weapons. And so you need to be mindful of that, to the extent that you've got employees who have a carry permit and they keep their concealed weapon in their car, and then they get a bad performance review, and they go out to their car unable to get this concealed weapon because they're now it's just much more accessible to this disgruntled employee than it otherwise would have been if that employee now had to go home and again think of time to prepare. So be mindful of what the laws are in your state for access to either banning concealed weapons on your workplace, or recognizing that if you are in a parking lot or individuals have cars on a parking lot, it may be permitted. The cost of workplace violence is significant. It continues to rise annually, and therefore this isn't just sort of a theoretical issue. This is an issue that you as an employer need to take and focus on, because it could have a real strong impact to your bottom line. And it's worth it to put the resources in place to make sure that you do have the policies and programs, and that those programs are working and you're training your staff. Because we can see not only just the cost of workplace violence, but that also results in lost productivity, frequent absenteeism, people leaving because of they're just not motivated to come to work, or they're recovering from an incident, or they're just fearful of coming into work because of issues in the workplace. So you've got lost work days. If it goes to litigation, if you've got some kind of employment-related liability, you've got significant multi-million-dollar scopes of settlements and jury awards. And what I think is interesting, too, is this is the last Bureau of Labor Statistics survey that talked about workplace violence. Fewer than 30% of employers had workplace violence prevention programs, and only 20% of those actually did training on the policies and programs. So one of the things you will hear from Eric and I repeatedly throughout the program is that this is really not only an important issue nationally and to your bottom line, but it's really important to take what you're hearing from us today and bring it back to your workplaces and start to implement a plan, because it will help you demonstrate, if anyone comes in, whether it's OSHA or some other agency, that you did have a reasonable plan in place, you were putting it into impact, and that it's not, it can defend against any kind of negligence claims or any claims from a federal agency. A couple of issues that we've seen just this year in the headlines. I mean, everyone on the phone probably are familiar with these, but you've got the restaurant down in Waco, Texas. What's interesting about this situation was it was, a biker gang issue. These were rival bikers. There was going to be a meeting that they knew well in advance was coming to the restaurant, and it ultimately led to 9 people dying. It was a workplace violence issue because it happened, in and around a workplace, what was a restaurant, but it didn't injure any employees. It didn't injure any customers. No police were injured. It was only the bikers, the rival gang members, that were actually injured. But that didn't prevent OSHA from coming in and investigating the restaurant, which happened to be a franchise restaurant. So they investigated the franchisee as the operator of the restaurant, but also investigated the franchisor and said, wait a second, what were you doing, franchisor, to make sure that the franchisee had the right types of workplace violence plans that we expect employers to have in order to maintain a safe workplace? And certainly as the law changes and moving forward with OSHA and other federal agencies' perspectives on joint employer relationships, this is an important issue for franchisors and franchisees to recognize that they could now be on the hook for potential OSHA issues on workplace violence impacts. And again, it's just because it was within the work environment and not necessarily involving employees or customers or guests of the employer. Most recently, we've got the TV journalists in Roanoke, Virginia, who were killed on air tragically, and that was a former coworker. That was someone who had mental health problems in the past, who coworkers had identified as being disgruntled and angry. He wasn't currently employed there, but he'd previously been employed, and he targeted the journalist because of his animosity towards that employer. And so that's an issue in terms of thinking through the things we'll talk about later in highlighting what could be a potential person who is violent, being aware of the importance of understanding coworker issues and understanding that it's important to report and do what you can with employees in the workplace. And then you've got the hospital issue. Eric will talk about this with unique to the healthcare industry, but you've got a security guard who was killed by a patient who was under psychiatric observation. And so you've got the unique issues there with someone coming in. It's a known third party, as Eric was mentioning. They're coming in and harming the security guard. So this comes from all different angles, as Eric talked about, and now we'll kind of get into the specific issues, both from an OSHA perspective and then from an employment perspective on potential liability.
Right. So, this workplace violence issue has become sort of a pet issue for OSHA over the last several years. And we'll talk about some of the origins of that. There was some pressure resulting from an Inspector General investigation into OSHA's enforcement efforts to encourage more enforcement in that area and also to encourage more compliance assistance. And OSHA has responded to that by doing both, by increasing enforcement and by increasing the volume of compliance assistance materials that they produce in that area. And really there's an overlap as well, because a lot of what OSHA puts out as compliance assistance, the agency ends up using to support its enforcement efforts, and we'll talk a little bit about that as well. As a starting point, let's talk a little bit about enforcement, and the timing here is interesting. I'm going to talk about an enforcement issue, and really any OSHA enforcement issue is a bigger deal today than it was even 2 weeks ago. As many of you may have already heard and may have received an email from me about yesterday, OSHA has just been given authority, in fact mandated by Congress and signed by the President, the authority to increase their civil penalties by approximately 80% in the first instance within the next 6 to 8 months, and then up to 150% increases in penalties over the next several years through cost of living adjustments. We've all operated under OSHA's penalty scheme of $7,000 per serious violation and $70,000 per repeat and willful violation. Those are set to jump now by August of next year to approximately $12,000 per serious violation and $120,000 per willful and repeat violation by way of a little known, little recognized provision that was slipped into the 2-year Budget Act as John Boehner was walking out the door and clearing the barn. He kept talking about clearing the barn for Paul Ryan, and he certainly did that by getting the Budget Act through, so there won't be a government shutdown. But as a gift to get that done, the Republicans in Congress did give up a significant increase in OSHA penalties. So as we think about OSHA enforcement of this issue and really any issue, understand that the penalties for this are about to skyrocket. But talking about workplace violence enforcement in particular, this is one of those areas where OSHA does not have a specific regulation. They don't have a standard like the lockout tagout standard or the bloodborne pathogen standard to address workplace violence, but they do have their general duty clause, Section 5A1 of the OSHA Act, which requires employers to provide employment and a place of employment that is free from recognized serious hazards. And to establish a 5A1 violation, OSHA must prove that an unregulated hazard, a hazard for which there's no standard, is recognized either by the employer or the employer's industry, and there is a feasible means to abate the hazard. That has been the mechanism that OSHA has used to enforce workplace violence over the last several years. And in particular, OSHA demonstrates this hazard recognition, that this serious hazard, in this instance, violence in the workplace, either by an employee, a coworker, or some third party, is recognized by a particular employer or by that employer's industry using several different resources. One is industry consensus guidance, and you see this, for example, in other areas of law where there is a trade group or an academic body or a group of scientists that put out a consensus document. Those types of documents are often cross-referenced by OSHA as proof that an industry recognizes a certain hazard. We've not seen so much of that in the workplace violence area. The next place that OSHA would look might be employers' own policies. And we have seen some of this in the workplace violence arena. And this would be, a violent incident occurs, and OSHA comes out to do an inspection of this, and they see that the employer has on its books or in its safety manual a section on workplace violence with statements that acknowledge that this risk of violence is something that this particular employer faces or recognizes or that's common in the industry. And OSHA will point to that and say, well, look, the employer acknowledges that workplace violence is a serious hazard that is faced by this particular employer or by this industry. They admit so in their safety manual. That's one place that OSHA might point to. Another place is your injury and illness records. You keep your 300 log incident reports, workers' compensation records. OSHA might look to those records and say, it looks like over the last 5 years, we've seen 6 or 7 or 10 or 100 different incidents of employees being injured in a circumstance that looks like workplace violence, either an attack by a patient, a robbery, a coworker assault, things like that. And they'll look to those records and say, either you did recognize that this was a serious hazard in your workplace, or you should have because the data is right in front of you. But the reality is the mechanism, the tool that OSHA is using more than any other to establish or to try to establish before the Review Commission that workplace violence is a recognized hazard by an employer or an employer's industry is by OSHA's own guidance documents. And they have put out several of these for specific industries documenting, some of the industry, benchmarking data about workplace violence, anecdotal stories about workplace violence in certain industries, and then describing different actions, recommendations for programs, engineering, administrative controls that folks in that industry can feasibly implement to address the hazard. So this is really OSHA's way of sort of saying what my mother used to say to me for many years: it is so because I say so. It is a hazard in your industry because we OSHA say it's a hazard in your industry, and you knew or should have known about it because we published these guidance documents, and we put them all over our website, and we mailed them around to a lot of employers, and we talk about them at speeches and things like that. So the idea is OSHA writes its own guidance document that says workplace violence is a serious hazard in the healthcare setting, or for taxi drivers, or for late-night retail establishments. And here are feasible means that you can implement to address that hazard. And then when they do an inspection at a healthcare workplace, or for taxi drivers, or at a late-night retail establishment, they say, well, look, it's a general duty clause violation because we, OSHA, told you that it was a serious hazard, and we, OSHA, told you how to address the hazard, and you didn't do enough to deal with it. So we've proven all of our elements of a violation by writing our own guidance document. So this is really the tool that OSHA has been using to enforce this. And they've been doing it at a greater clip recently over the last several years, and it's easy to see why. It's easy because producing a guidance document is a whole lot easier than putting out a new standard. OSHA could very easily put out a notice of proposed rulemaking, open up for notice and comment to interested stakeholders to create a workplace violence standard. And that would, perhaps be a good idea. Maybe all employers could benefit from a regulation that says, thou shalt implement a written workplace violence prevention program. Thou shalt conduct hazard assessments or security assessments to identify workplace violence risks. But rather than go through the arduous task of creating a standard, they create these guidance documents because it's easier. They also don't have to expose them to notice and comment like they do for a new regulation, and they have no obligation to go through an economic feasibility analysis to put out a guidance document like they do for a new standard. So that's why OSHA, even though we've seen a surge in these violations, has undertaken no effort that I'm aware of to actually create a workplace violence standard. They're very content to just, sort of write the law by way of guidance document. And according to OSHA, and if you look at the guidance documents that they have put out there, OSHA has expressed publicly that the hazard of workplace violence is well recognized, or it should be well recognized in certain industries. We've talked about healthcare, late-night retail, taxi, and other driver and remote operation industries, but less so. And I think OSHA acknowledges that the hazard is less recognized in other industries, or is less of a hazard in other industries. And so this sort of non-mandatory guidance we've seen, we talked about these three industries in particular where OSHA has put out a specific guidance document, but we've also seen OSHA has a full web page at OSHA.gov dedicated to workplace violence. And I think even if you are outside one of these three specific industries where OSHA has been putting out guidance, there is enough data on OSHA's website, I think, that OSHA could point to and say, look, the movie houses, we don't have a specific guidance document for that, but we do have a lot of guidance about workplace violence. You should have recognized this. There have been some high-profile incidents. You should have recognized this hazard, and you should have done more to address it. And just look at our website for a wealth of resources that any employer could have looked to. So if you are in one of these three industries that have a special guidance document, know that OSHA is looking over your shoulder. If you're not in one of these industries, that doesn't mean that you're off the hook, because OSHA has other sort of more generic guidance that they could point to use to support a general duty clause violation. I mentioned earlier that the Office of Inspector General in the Department of Labor conducted an investigation in 2001 into OSHA's enforcement of workplace violence. And the result of that investigation was there were lots of sort of mini findings and lots of interesting discussions. It's an interesting read if this is a topic that you're particularly interested in. But the real takeaway from that investigation was two primary recommendations. One is that OSHA should issue guidance, and really this is guidance internally to the regional offices, area offices, and compliance staff, whether workplace violence should still be cited under OSHA's general duty clause. There had been, by 2001, a couple of enforcement actions by OSHA under the general duty clause for workplace violence. And really what this OIG investigation was saying was put out guidance to your enforcement personnel to understand whether they should be using the general duty clause to enforce and in what circumstances they should be doing that. OSHA responded to that recommendation by saying, hey, look, our policy on this hasn't changed since a 1996 memo that we issued saying that workplace violence should be cited under 5A1 and that these cases should be elevated to the national office in Washington, D.C. for review and approval. And I'll talk about in a moment another tool that OSHA put out to respond to this investigation after this initial response. Second recommendation was to develop additional compliance assistance tools for employers for how to deal with workplace violence issues. And OSHA responded to this by issuing the 3 workplace violence publications that we talked about before, healthcare, retail, and taxi drivers, and then also produced its web page on workplace violence and a handful of other publications and statistics and things like that. So OSHA responded that, hey, this is inadequate. There is lots of adequate compliance assistance out there for employers on this workplace violence issue. So this is sort of the origin of a lot of what we're talking about, the guidance documents, the general duty clause citations, and the surge of enforcement that we're seeing now. Talking about those specific guidance documents, we've talked about the industries that have them. What's in there? One of them was recently updated, April 2015, the guidelines for preventing workplace violence for healthcare and social service workers. OSHA, it looks like they contracted with a new graphic designer. They got some exciting, splashy new cover for their guidance document, which was frankly one of the only or more significant changes to the guidance from the last iteration of it. But there were some interesting changes that were in there. We'll talk a little bit about that. So OSHA is uniquely focused on or very interested in the workplace violence hazard in the healthcare setting. And the reason is, cited by OSHA up front in this guidance document, and that is that nearly 70% of known workplace assaults occur in the healthcare setting. And that's, not necessarily unexpected or surprising given the environment where you have, a lot of third parties with patients, with visitors, with guests, things like that, and then also a patient population often that is dealing with mental health issues, being treated for mental health issues. And then another major factor is that over the last decade, or really couple of decades, our prison system has started to use our healthcare environments to house mentally challenged prisoners. That this is becoming sort of a secondary prison. So you've got a lot of opportunity here for violent incidents in the workplace setting and a unique environment to try and manage those hazards. So OSHA is uniquely focused on that hazard in this environment and has put out guidance to deal with that. The new guidance doesn't provide a lot of new recommendations, but it does provide a lot of new data and a lot of new thinking about causes of workplace violence in the healthcare setting, risk factors, what types of tasks, locations, and activities in the healthcare setting create unique risk of exposure to workplace violence, and then does introduce some new or at least more detailed descriptions of preventive measures that workplace employers can or should be thinking about implementing. Major recommendations coming out of that guidance, frankly the guidance also for retail and for taxi drivers and for all employers is similar, at least the first few, is create a written zero-tolerance workplace violence prevention program. OSHA wants to see a written program like you have your written bloodborne pathogens program, your written lockout-tagout procedures. You ought to have a written workplace violence prevention program. And then once you have a written program, you should be conducting employee training in the program itself, in the tools needed to de-escalate escalating violent situations, how to recognize escalating violent situations, and how to work hand in hand with either in-house security or third-party security mechanisms or resources that may be available in the workplace. In the healthcare setting in particular, healthcare and maybe prison setting, we've seen some enforcement actions in that area as well. There's recommendations about patient screening, identifying and keeping good records and communicating effectively with your staff about patients with a particular propensity for violence, a system for flagging a patient's violent history, and then providing all of the mechanisms we're talking about: security cameras, panic buttons, security personnel, making sure that you have staffed and provided enough of those tools to meet the level of risk at your workplace setting. And then the last big thing that OSHA did to sort of respond to the OIG recommendations, they basically remarked, look, we've already told our enforcement personnel that they should be using the general duty clause to enforce workplace violence. But they did just in the last couple of years, I think it was 2011, the end of 2011, OSHA pushed out a new, I call it a compliance directive. The title of the document is enforcement procedures for investigating or inspecting workplace violence. And the idea here was to create and push out to their enforcement personnel a set of uniform procedures for responding to incidents and complaints related to workplace violence and for conducting inspections both in the healthcare industry and in other industries where workplace violence incidents occur. And then also this guidance document, this enforcement procedures document, provided guidance to OSHA's enforcement personnel on how to develop a case, how to develop a general duty clause violation. In other words, how to prove that a hazard is recognized, how to document and prove that feasible means of abatement existed and were not implemented by the employer, and how to write those citations in the best way to be upheld by administrative law judges and the review commission. And then steps that the area offices could take to assist employers, but more significantly to help their compliance personnel in developing workplace violence enforcement actions. And then the document did include some tools for employers, recommendations for workplace violence prevention that modeled a lot of what I just talked about from the guidance documents that OSHA has been putting out. Put in place your written workplace violence prevention program, training, and things like that. So after that tool was issued, after this compliance directive was issued, we saw a big surge in enforcement actions of workplace violence. We saw in particular, and maybe this is anecdotal, but I have seen most significantly a surge in the Northeast of hospitals and healthcare providers of essentially a copycat citation being issued to hospitals for workplace violence issues. And what OSHA is doing in this copycat citation is basically quoting directly from their healthcare workplace violence guidance document. And when you see this in other settings like retail, they're doing the same thing, quoting from their guidance document to say, you recognize this hazard because, and they put all the information from their guidance document, and there were feasible means to abate the hazard, and they quote right from their guidance document about the recommendations to address workplace violence, and they say that the employer didn't implement these feasible means that we laid out in our guidance document. And we're seeing, these citations pop up all over the place, in particular in the workplace in the healthcare setting. Many of those citations being issued as willful violations right out of the gate, and then mostly being resolved through agreements by employers to implement enhanced workplace violence programs, either in exchange for penalty reductions, characterization changes, or in some instances withdrawal of the citations. And the circumstances are always, a high-profile incident occurs. A patient attacks a nurse. It's covered by the media. The union complains to OSHA. OSHA comes in and says, sort of, looked at your logs, we've looked at your programs, and there are a handful of workplace violence incidents that show up on your OSHA logs or in your workers' comp histories or in your incident reports. And whatever the number is, in OSHA's mind, if it's more than one, this ought to be cited. If it's more than one, they cite you for not doing enough to address the hazard. The reality is, obviously, no program is perfect, especially when you're dealing with those third parties or even strangers. And in this environment where you are trying to treat patients, a lot of what OSHA is asking healthcare employers to do would have an adverse effect on medical treatment. But they are just taking this hindsight 20/20 view and say, someone was attacked, therefore your program was inadequate, and here's our guidance that says what you should have been doing. And if you didn't do everything in this non-mandatory guidance, we're citing you for it. So this surge has happened. Employers are challenging it. And now, in a really interesting circumstance, just a couple of months ago, the OSHA Review Commission, in a very rare request, I can't remember ever seeing this before, but the Review Commission put out a request. There's always an opportunity for amicus, interested parties, to brief an issue to support an employer's defense or to support OSHA's prosecution of a citation. But in this instance, the Review Commission invited amicus submissions from interested stakeholders to comment on whether the general duty clause should apply in these circumstances, whether this hazard is recognized by the healthcare industry in this particular case, but I think this has broader implications. And then finally, and most importantly, whether feasible and effective means do exist to abate the hazard, and whether the tools that OSHA has been citing, i.e. its own guidance documents, reflect feasible means of abatement. My takeaway from this is that why would the Review Commission ask for this amicus support if they weren't skeptical of the manner in which OSHA was exercising its authority here? So that request went out 2 months ago. I think it was 30 days to respond. So the window has closed. It might have been 45 days, but I'm pretty sure the window has now closed for amicus parties to submit information or opinion or comment on these issues. But it is fascinating that they've asked. It will be fascinating to see how they digest the responses that were made. And what happens with this was done in the context of an active appeal. An administrative law judge upheld a 5A1 violation in a healthcare general duty clause workplace violence issue. And this was a case involving a home health care provider was attacked by a patient at the patient's home, and OSHA issued a general duty clause violation. And OSHRC is obviously skeptical of this, and it'll be interesting to see what they do with it. I mean, one scenario was to just, overturn the ALJ's decision and say not a valid violation. But the fact that they're soliciting input from the public on these high-level issues, whether 5A1 applies at all, whether these guidance documents are valid to demonstrate feasible means, really could have broader impact on OSHA if the review commission says none of this is valid or parts of this are not valid. It will have broader implications not only in healthcare and really not only on just workplace violence, but in all of the areas, all of the circumstances where OSHA tries to use its guidance to enforce the general duty clause. This may be the review commission stepping in and saying, sorry, OSHA, you cannot do what Eric's mom used to do and just say it's so because I say so. It has to be recognized by the industry, not just by OSHA. So it'll be interesting to follow that and to track that. I'm going to turn it over to OSHA to talk about some employment law issues, and then we'll be back at the end together to talk about different things employers can and should be doing.
Okay, thanks, Eric. Yeah, so there's a lot of different employment law implications to workplace violence. And just to sort of jump into them, you realize that you can find potential liability from all different places. Obviously, we'll discuss in more detail in a few minutes the claims that an employee or a third party can bring. But I want to take this point for you to emphasize that don't forget about exposure from both the victim and even potentially the accused or the violent employee. I mean, it's really important to evaluate all your legal risks from all different angles, because it may be easier to quickly act to protect a victim in a harassment situation, but yet overshadowing what the potential liability is if you terminate somebody prematurely or take action against an accused, you could open yourself up to invasion of privacy claims, defamation, wrongful termination claims, if that person feels like they were, a prompt, thorough investigation into a complaint of assault or threats or bullying behavior had not really given the accused an opportunity to provide his side of the story or her side of the story. So let's just dive into with employees and third parties. You've got vicarious liability issues. Generally, absent an agency special relationship, you have no duty to control the conduct of third parties in your workplace. But the employment situation creates that agency relationship, and therefore you have your employees who act as your agent for limited purposes. And those employees are expected to act within the scope of the employment, and to the extent that they do actions within the scope of their employment, you have a duty to make sure that those actions are safe and free of hazards, and that you're protecting not only them within the scope of their employment, but others as a result of their actions within the scope. And so if you do have an employee who acts within that scope and commits some type of workplace violence, that's where you have a duty to third parties and where your liability under the vicarious liability theory of law could come into place. Even in some circumstances, courts have found employers have a duty to control actions outside of the scope of employment. So it's, again, consult with counsel if you have an issue, but figuring out what you'll be held liable for and what you may not be outside the scope of someone's employment. In the hiring phase, we see this come up time and time again with a potential negligent hiring theory. And that's the argument that you've breached your duty to protect employees and third parties from being injured because you hired someone who you either knew or should have known was unfit for the job and was a risk of harm to employees. And so this ties into why employers often do background checks. And so if you don't do background checks and you've got someone who commits a violent act in the workplace, the question is, well, why didn't you do a background check? Why didn't you contact prior employers? Why didn't you check references? Why didn't you do, a criminal background check by, a company that's skilled in this? And if you don't do it, then you should, and had you done that background check, it would have uncovered information that would have given you information about the violent tendencies of this individual, and that could give rise to a negligent hiring claim. And it's important, though, but if you do have a background check policy, it's important you follow it, because it's much worse from a legal perspective, and certainly from a defense perspective, if you have a good policy on background checks and then you don't either use it or you don't follow up on it, and therefore you're exposing yourself to even broader potential liability. Another claim that can come into the realm of employer liability is negligent supervision and retention. And this happens when you've hired somebody, you've done that background check, it comes back clear, there's no reason for you to have any reason to believe that they may, have violent tendencies or they might not be fit for the job. But then something happens during the scope of their employment and they start to change or they become more agitated or information complaints are raised by coworkers about threats or bullying behavior. And then the question is, okay, are you properly supervising and retaining those individuals? Are you making sure that you're using ordinary care in supervising and making sure that there is no harm? Otherwise, it rises to a negligent supervision. This comes into times when you've got a harassment investigation and you see people who may be fighting in the workplace and you do an investigation, you reach your result and you decide, you know what, I'm going to discipline both of them. I'm going to give them written warnings. They're going to go to counseling, doing some training, but I'm going to continue to employ them. And then what happens if the next incident results in greater harm to another employee? That second employee is going to say, wait a second, you already knew that this person was violent. You've investigated him before, and therefore it was negligent of you to continue to retain him. They should have been fired the first time. And that's how these issues come up in the legal framework. So in order to avoid those legal theories, it's really key that you have policies and procedures to respond to workplace violence. It's not in addition to the OSHA issues that Eric mentioned and the requirements that OSHA puts in place, but also from an employment common law perspective and the negligence theories we just talked about. I mean, think about your policies. At a minimum, a workplace violence policy should have, a policy statement. It should talk about what conduct is prohibited. It should have a complaint procedure. If you have an employee assistance program, it's important to reference that EAP program if applicable. And other things you might want to think about doing is including signs of violent behavior, contact information for building security or law enforcement, and other additional information and helpful links as resources. If you think about having that policy, put it into your employee handbook, train your employees on it, make sure that they're aware of it, consider posting it around the place. But aside from workplace violence policies, think about this. Do you have a harassment policy? Hopefully everyone has a harassment policy in their handbook. If not, that's the subject of another call, but certainly think about that. As well as just a general respect in the workplace. I'm seeing more and more of our clients put in bullying policies and anti-bullying policies. Bullying is not prohibited by law, right? It's not a Title VII issue. Someone cannot claim that they were discriminated against because of bullying or create a hostile work environment because of bullying. It needs to be tied to a protected category. But more companies are creating a zero tolerance policy for acts of bullying or even threats or intimidating behavior, and that's something to think about incorporating into your policies and procedures. What about a policy for visitors in the workplace? Do you have a requirement that visitors need to be accompanied by a current employee, that they have to wear badges, that they're checked in by security, things like that. So you'll just want to make sure that your compliance and workplace policies are up to date. With respect to sort of risk management and insurance review, be aware that workplace violence insurance policies are available. They're similar to EPLI policies. They're not very expensive, and they can provide for reimbursement for things like counseling in a post-incident issue, dealing with stalkers, providing independent separate security, handling PR post-incident as well, even loss of business income. So think about whether you want to consider having a risk management and insurance policy in place to address workplace violence issues. With respect to kind of a physical security review and assessment, you want to be aware of your surroundings, the escape routes, your building security, and have a plan in case of an emergency. Obviously, different types of employers and different type of workplaces have different issues, but be aware of sort of the layout and security measures if you have cameras in place or your communication systems. How would they function in the case of an emergency? Do you have a backup plan? And then once those policies and procedures are in place, you want to ensure that employees and managers are trained on the policies concerning behavior, but also train on the policies about how to safely exit the building in the case of an emergency, or what to do, how to communicate with the employer remotely. And do you provide remote access if you have business email, or is it only through their home computers? Do you know how to access and notify family members if you have an incident on your workplace? In training employees too, I see that there's a question sort of how do you train employees to react to a shooting if the shooting is an employee? I mean, then arguably, are you training the employee about how to, find other employees in an active shooter situation? And I think there, I think it's probably a lot more important, I think Eric would agree, to have a training in place to make sure that you've got maybe even preventing shooting to begin with, but also that you're protecting the safety of your other employees. I think that if you could, it's pretty rare to have an active shooter situation, but I think if you do, it's really important that employees understand what to do in response to an active shooter situation, how to stay calm, how, where to go, what to do, how to notify 911 if turning off their cell phones so their cell phones can't be found. Those are specific trainings, and I think all the benefits that arise from that training and creating a safer workplace well outweighs the risk of potentially, educating a potential shooter of issues in the workplace. And then, you've got your prevention and response programs that we've talked about. But really, preventing workplace violence, it's not just an HR thing. It's not just a safety director thing. It is a team effort. All other parts of your business need to be part of this plan in preventing workplace violence. So you want to incorporate your facility personnel and management. I mean, that's the people that know your surroundings, know your safety practices, your security personnel. Obviously, you want your key business stakeholders involved. Media relations, making sure that they know what to do post-incident in terms of communicating with the media or PR, Twitter and Facebook, dealing with issues of family members. Financial, workers' comp, realize that mostly workers' comp is the sole remedy for workplace injuries, and so you want to understand how that comes into play, understanding your liability coverage, potentially of workplace violence insurance. In surveillance, you want to think about how to keep in mind with state laws and be compliant with how you can and cannot surveil employees, but also how you can have cameras in place, things of that nature. And then keep in mind when creating and communicating with your team, just be mindful of confidentiality. You don't want to open yourself up to a defamation or libel claim, again, if you're responding to a particular specific incident or complaint that might be brought by a coworker. So, background checks, I touched on this earlier as a really important policy to have in place with respect to negligent hiring claims. And there's a lot of information with employee background checks, and with the time that I've got, I'll just sort of cursorily cover it. It's important to really know right now the state and federal law guidance on employee background checks. The EEOC takes the position that only look into someone's convictions. You cannot look into someone's arrest history because there's a disparate impact on minorities. But more and more states are passing what we call ban-the-box laws. And what that means is that you cannot inquire into someone's criminal history until after an employment offer or conditional offer has been made, or at different stages in the employee hiring process, versus immediately upon an employment application. Traditionally, someone completes an employment application, gives you their consent to run a criminal background check, and employers have been doing that, but more states are passing the ban-the-box laws, and so really be mindful of what the laws are, where your workplaces are, to make sure you're complying with that, because you may be in states with very different requirements and different situations, and so one-size-fits-all policy on a background check may not work for your company. And then to the extent that you do conduct a background check, make sure you're complying with federal law, that you're documenting everything, including if you're doing reference checks on prior employers, and that you want to think about maybe supplementing background checks. This gets to the negligent retention and supervision issues that I talked about. If you're seeing someone that is exhibiting violent propensities, consider whether you want to have, recurring or mid-employment background checks during someone's employment. So then, we talked about this, combating workplace violence. Eric talked about the importance of having workplace violence prevention programs, conducting employee training. Do you want to add anything else about?
No, I think one of the things that is always an important part of the recommendations we see from OSHA in this area is not just training in programs and things like that, but it's also training in the reporting mechanism and making it a mandatory report to the employer. Obviously the physical assaults and the active shooter situations, the employer is going to be fully aware of that. But this is, would include obviously aggressive behavior, threats, things like that. That should be part of your written programs, and there should be training to make sure that you're getting reporting and encouraging reporting and making that mandatory, that you're hearing about those sort of precursor types of incidents. That would be a big part of how to catch things before they bubble into the bigger event.
Other issues to think about with respect to preventative measures, medical inquiries in addition to background checks. You might want to consider using psychological tests on applicants to try and screen out potentially violent employees, but you need to be careful on a couple of fronts here. Obviously, you want to be careful of disparate impact concerns, and that a test might have a disparate impact on a particularly protected class of employees, whether that's minorities or those with certain kind of psychological disabilities. And second, you should be aware that psychological tests that are designed to identify a mental disorder or impairment are considered a medical inquiry by the EEOC. However, psychological tests that measure personality traits like honesty or preferences or habits are not considered medical inquiries, and so therefore you can use those as something to identify an impairment. Performance management, that's really key. Performance management that is detailed, timely is important, since a lot of violent employees are reacting to what they see as unfair treatment by the employer. It is very difficult to provide constructive feedback to employees. A lot of managers and supervisors do not like completing performance evaluations, and they certainly don't like to be critical in employment evaluations. And so having honest and frequent feedback to employees, even if it's not formalized, in a big performance evaluation, but it's done contemporaneously, is really important so that you do avoid the situation that you've got somebody who is confronted with negative feedback, they feel like it's unfair, they go outside to their car, they get a gun out of their trunk and they come back in because they're still, they still have security badges, and that has happened at a workplace up in Pennsylvania. So just be recognizing that performance feedback that is fair and detailed, you're much better chance that the employee will not react negatively or violently, and so you want to make sure that you've got those procedures in place.
This is some sort of guidance just to a specific industry, and we've talked a fair amount about OSHA's views and some of their recommendations as it relates to the healthcare industry. Well, OSHA does have that other tool out there for recommendations for workplace violence prevention in late-night retail establishments. And we talked about the data where it was, I think, 70% of assaults are occurring in the workplace violence assaults are occurring in the healthcare setting. Well, 25% of workplace homicides occur in retail, according to the BLS, Bureau of Labor Statistics, and mostly at convenience stores, gas stations, service stations, and liquor stores. So that's a reason why OSHA put out this particular guidance document. And they identified some unique workplace violence risk factors for retailers, and those are that there is a direct exchange of money, often a direct exchange of cash in these settings, and therefore it creates a target for robberies. There is often work that's done by just one individual, often in isolated locations, often late at night. These are locations often where there's the sale of alcohol, and poorly lit locations. And I'm not sure that the locations are necessarily poorly lit, but that these work activities are happening at night, and there's grounds around the location that are not necessarily well lit. So those are the unique risk factors why OSHA has focused on this workplace violence issue in the retail industry with a particular focus on this industry. And then the recommendations that have come out of that, how to combat workplace violence in these locations, the recommendations from OSHA's guidance document are very similar to what we've talked about, not only for healthcare but in general, implementing a written workplace violence prevention program. But then OSHA went into some I think, pretty good detail in terms of a workplace security analysis, and they did that in the context of retail. But these are good thoughts for others as well, for folks in other industries, and that would be to evaluate the workplace, evaluate the work tasks and assignments and locations where employees work, to analyze past incidents. All of that to identify the conditions, the work activities, the operations, the situations, and the locations where employees are uniquely exposed to a higher risk, an elevated risk of workplace violence. So it might be, the types of stores, the areas, the types of patrons that frequent certain stores, the environmental factors, lighting that we talked about, things like that, the building layouts, interior and exterior lighting, communication and security systems that are in place, staffing levels. So evaluate your job tasks, your work locations, and your past incidents to find out where those risks are and whether the tools that you have in place are effective at addressing that hazard. And I thought that was a pretty useful set of recommendations, not just for retail, but for all employers. And it was something that OSHA recommended in that regard.
So we talked about training and knowing the profile of a potentially violent employee. I mean, these are some things that the government has set out as saying, some traits of what a potentially violent employee looks like. Someone who's a loner with few outside interests. A disgruntled person, either because they, got a bad performance review or they're just always disgruntled. And this is someone who likely wants to be in control. They're just not happy, so they blame others for all of their problems. Someone who has this desire for notoriety because of feelings of humiliation or rejection, things of that nature. Moodiness, stresses in personal life. I mean, the fascination with weapons and their killing power. I mean, this is particularly important for someone who previously had no interest in guns and weapons. And so that's where if you start to see, wait a second, someone's all of a sudden now going to the gun range where previously they never had that interest before, that might be kind of a red flag. Importantly, there's no simple checklist that can anticipate all situations. And obviously some situations come on so quickly that they're hard to assess. But we kind of just wanted to set out some of the common signs. And really, bystanders are critical, right? They are the best way to identify and prevent workplace violence. So these are going to be your coworkers, the managers, the customers that visit your places of business. Make sure they're aware of warning signs, and more importantly, that they know how to report it. A lot of times people observe these warning signs and disruptive behavior, but they don't know how to respond. Or they say, oh, well, that's Joe being Joe, and they don't take it seriously enough. Whereas had they reported it and knew, the process for reporting it, then that could go a long way to avoiding a more serious situation. Other behavioral signs that could precede, a violent act, unexplained increases in absenteeism. A lot of times, someone who's right on the cusp of an active shooter or a violent act, they'll start to seek more privacy. What's called cocooning. And what it is they're preparing themselves both mentally and physically for engaging in a violent act, even if it's just, suicide or self-violent act. Other traumatic events or, I mentioned earlier, humiliation or rejection. This idea of heightened verbal threats or physical acts in the workplace. If you see someone escalating in their violent tendencies towards others, either as a result of, other internal issues or external issues, depressed behavior, it's that escalation of the reckless behavior that's going to be really important. Increased arguments at work, increased, altercations with coworkers. And then the legacy token, that's really one of the last signs. And what this means is, this is the idea that someone's going to leak their behavior on social media, either through a blog or a website or Facebook, or they start talking to colleagues about it. They're creating a video. We see those a lot, the video manifestos or the Facebook manifestos about their attack before the attack happens. Those are the kinds of things, if you see that, that is definitely the biggest red flag and one thing you want to immediately report. Your open door policy and even litigation as a nonviolent reaction to criticism, that's better than violence. And so reinforcing that, okay, you've got these other avenues to explain and, fight your feelingness of helplessness and unfairness. Those are a better way to resolve your disputes, certainly, than violence. And then the last thing that we wanted to do before addressing some questions was, what else can you do if you're faced with a potentially imminent threat of workplace violence? And I don't know if a lot of employers know this, but the FBI has a behavioral analysis unit. And what they do is they've got a group that will work with you, and they'll do a clinical mental health assessment. They'll send a team out, work with you directly to conduct a threat assessment if you feel like you've got somebody who's really rising to a serious threat in the workplace. It's a key to have them in place as soon as possible, and they work immediately. You can call them, they'll get a quick assessment, and they could be on your workplace, within hours or within a day. And what they do is they do an individualized and holistic view of the employee to assess the level of concern. So it's not just, just the threats, but they really look at it from all different angles, which is a little bit of a different perspective that you'll be feeling. And so sometimes it's just nice to have that outside resource and those experts from the FBI who can really help you if you feel like you've got a serious potential active shooter situation that might be brewing at your place, or even less severe. And then you can always obtain a restraining order. I mean, a restraining order is a court order that restricts someone from harassing or threatening other people. And so there's some different laws that vary as to whether you as the employer can seek a restraining order on behalf of yourself or instead of on behalf of an employee, but certainly knowing how to assist an employee to seek a restraining order, whether it's against victims of domestic violence or other harassment situations. It's important to know your state law on that regard because states do vary. So that is our presentation, and we can open it up for questions. We will be sending out, all the slides from the presentation, and this is being recorded. So if there's people from your organization that were unable to attend today, hopefully they can benefit from the slides and the recording. And another question that's just popped up on our chat is, should an active shooter training be mandatory or voluntary? I mean, I think that's really a business decision, although I think that if you're going to do a training, it really should be mandatory. I mean, it's really important that if you're going to take the time to have a prevention plan put in place, you want to make sure that training reaches as many people as possible, and you should have people who are required to attend that so they understand the resources that the company has as well as what your policies and procedures are. And it can go to help prevent and support defenses against the negligent claims that we talked about, as well as OSHA's enforcement.
Right. I mean, that was my thought about this. This is a subject that could affect any employee. It's not like it's my my maintenance staff versus my production staff versus my front office staff, where some hazards are unique to one group or the other. This is an issue that, God willing, affects nobody, but could affect everybody or anybody. And so there's not a group that I would carve out of the training. And then secondly, as Cara just mentioned, we do the training because we want to, create a safe environment. But having done the training will be evidence supporting your efforts in an area where there's no standard, right? This is the general duty clause, so it's real loose, it's real flimsy what's required, and you want to be able to point to everything that you've done to meet this general duty burden. And so I think if you're going to do training, and I do think you should, the training should be mandatory, it should be documented, you should keep a record of who participated and what was covered. And that's not just active shooter training, but all of the training that we've talked about under your workplace violence prevention program, recognizing escalating situations, how to de-escalate them, what to do if you can't or it doesn't make sense to try to de-escalate, how and when to report, what's required to be reported. I think all of that should be covered in your training program, and it should be mandatory, and it should be recorded. There's a really interesting question here. I'm not sure how really to tackle it. The question is, how do you do effective training for employees on how to react to an active shooter situation when the active shooter is often a co-employee? And aren't you then essentially training or teaching the shooter where to find employees, what the code is for all clear and things like that? And I think that's one of these situations where, this is sort of a best practice that FBI and other law enforcement have recommended. And even though you've got perhaps the active shooter in the room with you, very often it's not the case that it is a co-employee. These active shooter situations lately have been outsiders. But even if it is a co-employee, these are just good practices that even if the shooter knows about them, and you have to anticipate, and I don't put myself in the minds of these shooters, but they are preparing for their attack, and they know about these best practices and things like that. So I don't think you should avoid the training by in an effort to avoid giving that tip to the shooter. But what an interesting question, and it creates some of the really the tension in this whole issue about workplace violence being it's a hard hazard to manage. It's not a machine. These are human beings that do things that often are hard to foresee, and very often are third parties. How do you prepare for this? And that's a really interesting question that goes to that issue.
So another question that just came in, which is an interesting one. What is the company's liability if you have a violent, aggressive individual with or without a weapon and an employee, supervisor, or manager who addresses the situation and injures or kills the aggressive individual? So in terms of the company liability, and this would also probably be true, for company. So workplace injury. So largely, if it's injury, it's covered by workers' comp. And the question is, there's limited exceptions for workers' comp if there's a specific intent requirement, which is very narrowly construed. And again, workers' comp is driven by state law. But if there's an injury, you've got a workers' comp bar for liability. The question is, you've got, if it's kills, you've got a self-defense defense if there's criminal liability, but civil liability really likely will be governed by workers' comp. And then the question is, okay, well, you probably, was it negligent? I mean, was he somehow negligent? And if you're addressing that situation reasonably against a violent, aggressive individual, you probably, won't be found to be, negligent if you're injuring that other employee. But that's where, if it's an employee and you've got a violent, aggressive individual, I'd really encourage in your reporting and training materials that employee get someone else involved, a manager or a supervisor or particularly security. I mean, that's where you really shouldn't be engaged in a violent, aggressive situation, if you're able to get security. But if you're not able to get a security and you address the situation, I think the company's liability is largely limited to workers' comp and or, a response to any kind of third-party negligent, supervision or retention.
All right, well, we've kept you all for a long time today. We appreciate you joining us. This is an interesting topic, I know, for me to research, and Cara and I talked about it at, one of these really interesting topics that you see top-level stories on CNN, but also that we're dealing with for our clients on a day-to-day basis. So we invite you to contact us after today if you have other questions or anecdotes or stories to share or advice for us in this area, and likewise, we'd always be happy to talk with you about the issues that you're encountering in your workplace. So really great discussion. Thanks for joining us, and we hope that you will join us for future webinars either on the OSHA or the employment front. Thanks very much.